On Thursday, the Supreme Court handed down the biggest 2A win since Heller. The decision on New York State Rifle and Pistol Association versus Bruin not only fortifies the right for Americans to carry outside the home, but it sets a precedent that could be used to strike down all kinds of other Second Amendment infringements. Before we get into the details, I want to give a shout out to Blackout Coffee for supporting the channel and the Second Amendment. Head on over to blackoutcoffee.com/libertydoll to get your fill of coffee, tea, and hot cocoa, or send a coffee care package to deployed troops overseas. The case centered around New York's May issue licensing scheme, which required citizens to show what they called good cause for needing to carry a gun, rather than simply meeting licensing requirements for not being a prohibited person and wanting to exercise their rights. The Supreme Court ruled that New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. Justice Clarence Thomas explained, "In Heller and McDonald, we recognized that the Second and 14th Amendments protect the right of an ordinary, law-abiding citizen to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary, law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree, and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home." He continued, "The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It's not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him, and it is not how the Second Amendment works when it comes to public carry for self-defense." This in and of itself is a huge win, but equally important is the part of the decision that talks about the one-step test for laws attempting to limit 2A rights. Basically, according to the opinion, gun control laws should be tested against the historical interpretation of the Second Amendment, along with the tradition of how it was exercised throughout American history. Under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, and to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. So basically, if some new big bad gun control law comes along and it's tested against the history of American tradition of gun ownership, it should be found unconstitutional. In theory. Since Heller and McDonald, the courts of appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court rejects that two-part approach as having one step too many. Step 1 is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support a second step that applies means and scrutiny in the Second Amendment context. Heller's methodology centered on constitutional text and history. It did not invoke any means and test, such as strict or intermediate scrutiny, and it expressly rejected any interest-balancing inquiry akin to intermediate scrutiny. So, reason follows, this ruling could be used in future lawsuits to strike down things like magazine bans and even potentially assault weapons bans, though I'm sure that blue states would fight that like hell. Already, California and New Jersey have backed down on their own justifiable need provisions. California's Attorney General put out a press release stating, "Effective immediately, issuing authorities should no longer require proof of good cause for the issuance of a public carry license." The press release does, however, stress that licensing authorities should still establish good moral character and issue licenses only to individuals who prove they can be trusted to carry a gun, quote, by virtue of their character and temperament. The AG argues that showing proof of good moral character will require a separate determination in order to be struck down. New Jersey did something similar, reminding folks that they will still need to supply 3 character references. Meanwhile, of course, blue state governors are vowing to try and find ways to circumvent the decision, but for now, that will be a battle for another day. That is it for today's video, short and very, very sweet. So please celebrate, like, share, and subscribe. Check out the description for various support options, and as always, stay safe and happy shooting.